Article 19. A person charged with a criminal offense shall be given a fair hearing within a reasonable time by a court. Clause 2. A person charged with a criminal offense shall a. In the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and a jury, and I. Where the punishment is death, the verdict of the jury shall be unanimous, and II. In the case of life imprisonment, the verdict of the jury shall be by such majority as Parliament may by law prescribe. B. In the case of an offense triable by a regional tribunal, the penalty for which is death, the decision of the chairman and the panel members shall be unanimous. C. Be presumed to be innocent until he is proved or has pleaded guilty. D. Be informed immediately in a language that he understands and in detail of the nature of the offense charged. E. Be given adequate time and facilities for the preparation of this defense. F. Be permitted to defend himself before the court in person or by a lawyer of his choice. G. Be afforded facilities to examine in person or by his lawyer the witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of witnesses to testify on the same conditions as those applicable to witnesses called by the prosecution. H. Be permitted to have, without payment by him, the assistance of an interpreter where he cannot understand the language used at the trial. And I. In the case of the offense of high treason or treason, be tried by the High Court duly constituted by 3 justices of that court, and the decision of the justice shall be unanimous. Clause 3. The trial of a person charged with a criminal offense shall take place in his presence unless a. He refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified by the trial, or b. He conducts himself in such a manner as to render the continuation of the proceedings in his presence impracticable, and the court orders him to be removed for the trial to proceed in his absence. Clause 4. Whenever a person is tried for a criminal offense, the accused person or a person authorized by him shall, if he so requires, be given within a reasonable time, not exceeding 6 months after judgment, a copy of any record of the proceedings made by or on behalf of the court for the use of the accused person. Clause 5. A person shall not be charged with or held to be guilty of a criminal offense which is founded on an act or omission that did not, at that time it took place, constitutes an offense. Clause 6. No penalty shall be imposed for a criminal offense that is severe in the degree of description than the maximum penalty that could have been imposed for that offense at the time when it was committed. Clause 7. No person who shows that he has been tried by a competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or any other criminal offense of which he could have been convicted at the trial for the offense, except on the order of a superior court in the course of an appeal or review proceedings relating to the conviction or acquittal. Clause 8. Notwithstanding Clause 7 of this article, An acquittal of a person on a trial for high treason or treason shall not be a bar to the institution of proceedings for any other offense against that person. Clause 19. Paragraphs A and B of Clause 2 of this article shall not apply in the case of a trial by a court martial or other military tribunal. Clause 10. No person who is tried for a criminal offense shall be compelled to give evidence at the trial. Clause 11. No person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. Clause 12. Clause 11 of this article shall not prevent a superior court from punishing a person for contempt of itself, notwithstanding that the act or omission constitution the contempt is not defined in a written law and the penalty is not prescribed. Clause 13. An adjudicating authority for the determination of the existence of extent of a civil right or obligation shall, subject the provisions of this Constitution, be established by law and shall be independent and impartial, and where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Clause 14. Except as may be otherwise ordered by the adjudicating authority in the interest of public morality, public safety, or public order, the proceedings of any such adjudicating authority shall be in public. Clause 15. Nothing in this article shall prevent an adjudicating authority from excluding from the proceeding persons other than the parties to the proceedings and the lawyers to such an extent as the authority a. May consider necessary or expedient in circumstances where publicity would prejudice the interest of justice, or may be empowered by law to do the interest of defense, public safety, public order, public morality, the welfare of persons under the age of 18, or the protection of the private lives of persons concerned in the proceedings. Clause 16. Nothing or done under the authority of any law shall be held to be inconsistent with or in contravention of the following provisions. A. Paragraph C of Clause 2 of this article, to the extent that the law in question imposes upon a person charged with a criminal offense the burden of providing particular facts, or B. Clause 7 of this article, to the extent that the law in question authorizes a court to try a person of disciplined force for a criminal offense, notwithstanding any trial and conviction or acquittal of that member under the disciplinary law of the force, except that any court which tries that member and convicts him shall, in sentencing him to any punishment, take into account any punishment imposed on him under the disciplinary law. Clause 17. Subject to Clause 18 of this article, treason shall consist only a. in levying war against Ghana or assisting any state or person, or inciting or conspiring with any person to levy war against Ghana, or B. in attempting by force of arms or other violent means to overthrow the organs of government established by or under this Constitution, or C. in taking part or being concerned or inciting or conspiring with any person to take or take part or be concerned in any such attempt. Clause 18. An act which aims at procuring by constitutional means Clause 18. An act which aims at procuring by constitutional means an alteration of the law or of the policies of the government shall not be considered as an act calculated to overthrow the organs of government. Clause 19. Notwithstanding any other provision of this article, but subject to clause 20 of this article, Parliament may, by or under an act of Parliament, establish military courts or tribunals for the trial of offences against military law committed by persons subject to military law. Clause 20. Where a person subject to military law who is not in an active service commits an offence which is within the jurisdiction of a civil court, he shall not be tried by a court martial or military tribunal for the offence, unless the offence is within the jurisdiction of a court martial or under the military tribunals under any law for the enforcement of military discipline. Clause 21. For the purpose of this article, criminal offence means a criminal offence under the laws of Ghana.